Hi, this is Rajeshkumar. Good morning, everyone. Today we are going to analyze one problem question on consideration. Here, the M was planning to have a party, and A agreed for to do this party for £1,000. A week before, A demanded additional £1,000, and M agreed to pay additional money. A day after the party, M changes her mind about paying the extra. The question is going to revolve around this. We are going to analyze today. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Mia is planning to hold a party at her house to launch her new interior design business. She speaks to her neighbor, Guldeep, to warn her about potential noise on the evening of the party. Guldeep promises that she will not complain about the noise if Mia agrees not to insist on the full repayment of £200 that Guldeep owes Mia. Mia agreed that Guldeep need only pay her £100. Mia contacts Andrew, the owner of the Party People, a local business that supplies catering services. Mia asks Andrew if his company can provide a buffet food and cocktails on the night of the party. Andrew's business has been going through a slump and he is in a serious financial difficulties. The party offers Andrew the opportunity to attract new clients for his business, and so he undertakes to provide the service at a reduced price of £1,000. A week before the party, Andrew realizes that it will be impossible to provide both food and cocktails for the price agreed. Andrew telephoned Mia in a panic, shouting, "There is no way I can do this for the price promised. Unless you pay me double, I will not be doing the job." Realizing that she would need to pay £200 for the same services elsewhere, Mia agrees to pay Andrew the additional money. The day after the party, Mia changes her mind about paying the extra £1,000 to Andrew. She also regrets her decision to forego the £100 that Guldeep owes her, and we have to advise Mia on the situation. Mia's scenarios involves issue of consideration and the contract modification. This question centers on whether Mia can retract her agreement to forego a part of the Guldeep's debt and withdraw her agreement to pay Andrew an additional £1,000. The discussion involves The discussion involves the doctrine of promissory estoppel, economic duress, and the practical benefits, particularly under the guidance of relevant case laws. First one is the gold dips debits. Gold dips promises not to complain about Mia's party night in exchange for a reduction in her £200 debt to £100. The issue is whether Guldip's promise not to comply constitute good consideration for Mia's agreement to accept party payment of the debit. The general rule for the Fox versus Bear in 1884 is that the part payment of debit cannot discharge the full obligation unless the debitor provides some additional consideration. This rule, grounded in Pinnell's case in 1602, suggests that Guldir's payment of £100, a lesser sum, does not provide a consideration for Mia's promise to forgive the remaining £100. However, in Williams versus Rofis, Bros and Nichols, Contractors Limited in 1991, the Court of Appeal developed the concept of practical benefits. where a promise to pay more in return for completing an existing obligation could constitute a consideration if the promisor obtained some benefit, while William versus Rofe dealt with paying more for performance. It does not apply easily to part payments or debts, as clarified in Re Select More Limited in 1995, where it was held that Williams versus Rofe did not overrule Fox versus Bear regarding the part payments. So, in Guldeep's case, the promising not to complain about the noise likely offers no practical benefit to Mia that can justify the part payment of debt. So, therefore, the Mia's promise to accept £100 is unforeseeable. Next, we are moving to a promissory estoppel. However, a promissory estoppel could prevent Mia from retracting her promise if Guldeep relied on the promise to her detriment. In Central London Property Trust Limited versus High Trees House Limited in 1947, Jennings J. established that a promise made without consideration may be enforced if it relied upon, and it would be inequitable for the promiser to go back on their words. If Guldeep has acted upon Mia's promise, for instance, paying the £100 based on Mia's assurance, Mia might be stopped from demanding the remaining £100. But the promissory estoppel acts as a shield, not a sword, meaning it can only suspend Mia's right to enforce the debt, not extinguish it permanently. So Andrew's additional £1,000. Mia agreed to pay Andrew an additional £1,000 after he threatens to not perform his catering services unless she pays more. The key issue are whether Andrew's promise to perform for extra money is supported by the consideration and whether Mia's agreement was made under the economic duress at consideration the practical benefits. In Williams versus Roseferry Bros case, the Court of Appeal held that when one party promises extra payment to ensure the completion of work already contracted for, this promise can be enforceable if the promiser gain a practical benefit. In this case, Mia agreed to pay more to ensure that the catering services was delivered as agreed, which would likely be seen as a practical benefit. The Andrews completion of the contract and the avoiding the inconvenience of hiring another caterer may count as valid consideration under a Williams versus Roffey principle. However, if Andrews' demand for more money was made under economic duress, Mia's promise to pay the extra £1,000 would be voidable. In Atlas Express Limited versus CAFCO, the Importers and Distributors Limited in 1989, the court held that an agreement extracted under economic duress was not enforceable. Here, Andrew threatened not to perform unless Mia agreed to his new terms, which would amount to illegitimate pressure, particularly if Mia had no practical alternative but to agree. To establish the economic duress would need to show that there was a threat to the breach of the contract. She had no practical alternative but to comply. The third one is the pressure was illegitimate. And the final one, she was caused to into the agreeing. If Mia can prove the economic duress, she may void the contract and refuse to pay the extra £1,000. So, to conclude, the Gulden's debt, a mere promise to accept a part payment, is likely unenforceable under focus beer unless the promissory estoppel applies due to reliance on the promise. If estoppel applies, a mere may be prevented from reclaiming the full debt for now, though it does not extinguish her legal right permanently. What about the Andrew's additional payments? A Mio's promise to pay the Andrew more may be enforceable due to the practical benefit she received under the Williams's roofing. However, if Andrew's demand for more money was made under economic duress, Mia may be able to void her agreement to pay the extra £1,000. Thank you.